concentrating in criminal and civil antitrust, fraud, and related matters. Prior to going to Squire Patton Boggs, Mr. Dugan served for more than 15 years at the DOJ, where he appeared in federal courts throughout the country on behalf of the Antitrust Division. He worked in the Antitrust Division's National Criminal Enforcement Section, where he led investigations and prosecutions of a number of international cartel matters. Mr. Dugan graduated from William & Mary in 1985 and received his law degree from George Mason, where half of this room received a law degree. He received it in 1990. Without further ado, Brady.
All right, let me just make sure that the electronics working first. This guy's already is on. Valley, this is flummoxing. But you know what? I'll just use the laptop. Let's see. I think I have to turn this thing on as well.
It's on.
You're good.
Oh, I will. There we go. Awesome.
Okay, so thank you all very much for coming. I appreciate it. As Melissa said, I'm Brady Dugan from Squire Patton Boggs. And while I doubt there are many of you that are really excited about this topic first thing in the morning, I think it's a pretty interesting topic, and I enjoy talking about it because I think it really goes to the basics of what it means to be a lawyer, particularly in Washington. I mean, what happens is we get hired by a client, right? And a client agrees to pay us a huge sum of money. And the reason they want to pay us a huge sum of money is because they have very difficult problems that they would like us to help them solve, right? So these are problems that if it's a business, will go to the heart of the business, will be confidential problems. If it's an individual, they're usually very personal problems or private matters. It goes without saying that they don't want you to reveal this information to anyone else. But that point almost gets skipped over when you start working on that. You immediately go to, I think, because I did at least, how do I solve this problem? How do I be a good lawyer for my client? But you have to not just solve the problem, you have to solve the problem in a way that keeps all of the information that your client gave you private. That is your obligation to your client, but it's not just your obligation to your client. If you get it wrong and the information becomes public, you'll have to turn the information over to the other side. You will likely lose the matter if you're in or at least there's an enhanced chance that you will lose the matter. If you're in a litigation, you will probably get fired by your client. And then at the end of all of that, you could be disbarred for doing so. There is a strong incentive to pay attention to this. We are in a small enough room that if folks have questions or comments or real-life experiences that they'd like to throw out, that's perfectly fine with me.
So let's see if I can figure this thing out.
Okay, so just one thing to make clear. What we're going to be talking about today is really the evidentiary privilege that attaches, that's called attorney-client privilege. We are not going to be talking ethics. This is not an ethics CLE. We're not going to be talking about the state bar rules. That would be completely separate. So all of this discussion today, this law of attorney-client privilege, is essentially an evidentiary law. I mean, that's really a fairly good way to think about it, and to sort of prove my point, and we'll talk about this in a minute. These laws are summarized in the Federal Rules of Evidence, Rule 501 and Rule 502. But let's go over just very quickly what we're going to talk about today. What I want to do first is give you all a grounding in what the law of attorney-client privilege is in the United States. And it's a little bit complicated because there's not really a single law of attorney-client privilege in the United States, but there's a pretty good stand-in for that. There's a case that is a pretty good stand-in that everybody uses. So there kind of is a law of attorney-client or a single law of attorney-client privilege in the U.S. And then I'll talk about a little bit about the fact that attorney-client privilege is different in foreign jurisdictions. You might think, well, of course it's different. The entire law of a foreign jurisdiction is different. But if you work in Washington, which I assume most, if not all of you do, you likely will be involved in transactions that involve foreign jurisdictions. If you haven't already, I mean, perhaps many of you do that regularly. I do it regularly. If you haven't, you probably will. At some point in your career, be involved in a matter that touches a foreign jurisdiction. So you've got to think then, well, gosh, my basic obligation to my client is to keep this stuff private. How do they do it in the foreign jurisdiction? And am I at risk of revealing everything that my client has told me just because we're in a matter that touches multiple jurisdictions? So I'm not necessarily going to answer that question for you today, but I hope to raise awareness, I guess, is the best way of putting it. That the laws are different, they don't necessarily work the same. It's a little bit tricky to navigate. And then at the end of this, I will give you a few tips just based on what I've done, what others have done, as to at least how to think about protecting these companies when you're working in a multi-jurisdictional manner. Okay, so why do we have attorney-client privilege? I mean, you can read that case at your leisure, I guess, from 1833. I think everybody knows that we have the attorney-client privilege so that people will use lawyers, and so that we'll get fees, and so that we'll all be happy. If there wasn't a way to protect this stuff from giving an ability to not have to turn this over in evidence, then nobody would ever tell us anything, and that's essentially what Hatton v. Robinson said back in 1833. So that's sort of starting with federal common law, and then you look to the rules of evidence. As I said before, Rule 501, I haven't put it up here, but Rule 502 is the rule on inadvertent disclosure of attorney-client privilege. The federal rule is not, and this is the old federal rule in 2011, the rule is exactly the same, but they reorder the parts of it a little bit. So if you open the rules of evidence now in 501, it's slightly clearer. But what the federal rules say essentially is, with respect to attorney-client privilege, you look first to federal common law. This is a federal matter, and presumably it is if you're looking at the federal rules of evidence. But you have to consider privileges that may exist in other sources, such as the Constitution or other sources. And then if you are in federal court, but you're dealing with state law, then look to the state law. So the Federal Rule 501 is not terribly helpful as to what attorney-client privilege is. It just tells you what body of law you should look to when you're trying to decide what attorney-client privilege is. So one of the things it says is look at federal case law. So or federal common law. Let's look at federal common law. Way back almost 100 years ago now, United States v. Louisville and Nashville Railroad. The law is so well known on attorney-client privilege that we don't even have to talk about it. In that federal common law, at least that was a federal common law in 1915. Everybody knows what attorney-client privilege is. So just do it. Protect the companies and don't mess up. This goes to my point that it is a subject that is very fraught. It is a subject that there's not a whole lot of clear guidance on, but it gets a little better. It gets a little better. Let's see. Okay, so that was 1915. If you flip forward in the federal common law to 1950, there is a case, a district court case, and this is the case that I mentioned at the beginning of my remarks today, that almost everybody turns to when they're talking about the law of attorney-client privilege, the federal law of attorney-client privilege. It's United States versus United Shoe Machinery Corporation. And what does that case tell you? Well, okay, so what is attorney-client privilege? Attorney-client privilege is when you have a communication, right? There has to be communication between a client. There has to be a client and someone who is either barred, who is a lawyer in a jurisdiction, or who is working for a lawyer in a jurisdiction on a legal matter. The communication has to be when the lawyer is acting as a lawyer. When the lawyer is acting as a lawyer, you might think, well, shoot, that's fairly obvious for all lawyers. We're always all acting as lawyers. But that's not true, and it's particularly untrue when you are dealing with in-house counsel. There are many times when an in-house counsel will wear two hats, will provide legal advice to his client, the company, but will also provide business advice to his client, the company, or her client, the company. So if she's providing business advice to her client, that does not get the protections of attorney-client privilege. So you have to be acting as a lawyer, and we'll talk a little bit more about that in a minute. And the communication that was made between the attorney and his or her client has to have been made in confidence. There cannot be any third parties present unless those parties can reasonably be said to be subordinates of the lawyer, so essentially acting on behalf of the lawyer. And what does it mean? What kind of communication does it mean to be acting as a lawyer in this context? Well, a legal opinion certainly qualifies. Assistance in a legal proceeding like litigation or appearing before an agency, I mean, that certainly qualifies as well. And then there's this third category that is sort of a catch-all category that's called legal services. If the primary purpose of the communication was to secure legal services, then the communication also falls within the privilege. Okay, so there's the crime fraud exception. We're not going to spend a lot of time on the crime fraud exception, but the communication cannot have been for a criminal or tortious purpose. If the communication was for a criminal or tortious purpose, then the attorney-client privilege never attached to that communication. And the privilege can't have been waived. And we will spend a little bit of time on that because you can inadvertently waive the privilege. You can waive it on purpose sometimes, but there are other times when it becomes waived and you don't realize it was waived. So we'll talk a little bit about that. All right, so client, it has to be a communication between a client and a lawyer. What is a client? Who is the client? There is pretty good case law on that in the United States, and when you are dealing with a corporate client, the seminal case is Upjohn versus United States, versus United States in 1981. That case really changed the law of attorney-client privilege with respect to corporations. Prior to Upjohn, if you were representing a corporation, you only could get the attorney-client privilege to attach to communications among members of that corporation's control group, right? I mean, folks that actually had the ability to direct and control the corporation CEO or the members of the board of directors or other officers of the corporation. If you were talking to a janitor at the corporation, it was pretty clear that the attorney-client privilege did not attach to that conversation. Upjohn said, no, that is too limited. The control group test is wrong. What you have to really look at when the corporation is the client is the information necessary to supply the basis of the legal advice? Do you need the information that you are gathering from the corporation in order to provide the legal advice that's really the basis of the attorney-client privilege? So they waive to the control group test. I mean, you have to be able to show that this information was not available within the control group. If it was, if you could have gone to an officer or a director or a CEO or board member and gotten the information, but you chose instead to get it from the janitor, then that potentially would not be privileged information. But in 9 times out of 10, when you all are talking to folks below the control group at a level of just a worker, a salesman, you're talking to that person probably because you're doing an internal investigation, or you're talking to that person probably because you are otherwise trying to gather facts to help you understand more about the company. So this idea that you have to think about going to the control group first is generally not a problem at all. I mean, you typically do not have to think about going to the control group first. The communication has to be about stuff within the scope of the employee's employment. If you were talking to this employee about his or her divorce, or about a drunken driving conviction that their child had, or some other matter that is not within the scope of that person's employment, then that will not be covered by the attorney-client privilege. Okay. Of all of the Upjohn rules for protecting attorney-client privilege with respect to a corporation, the last two on this slide are the most important. The employee has to know that the information you are gathering from him or her is necessary to secure legal advice for the corporation. What does that mean? You have to say to the employee that you're talking to, hi, I'm John Smith. I don't represent you. I represent the corporation. And we're going to have a conversation today, and the information that you are giving me today is very important because I will need this information in my job as the lawyer for the corporation, not as a lawyer for you. Communication, the last point, communication was considered confidential, and its confidentiality was maintained. So again, at the beginning of the conversation with the employee, when you explain that you represent the corporation and you don't represent the employee individually, you also said, this communication is privileged. In order to maintain the privilege, we have to keep this communication confidential. I'm not going to tell anybody what you told me today, and I hope you won't tell anybody either. If you do that, that's enough to meet the Upjohn test. And, whoops. Yeah, there we are. And you should be okay, at least to start with, to attach the privilege to that communication. So, the key question out of Upjohn, or that Upjohn answered, is when is the corporation, when can a corporation be considered the client? And I think we've talked about this already, but I will just read it. Whenever you are talking to an employee of a corporation, you have to give what's called an Upjohn warning. You don't have to say that to the individual. And frankly, most of you, many of you may already know this, but I'll say it anyway for those who don't. You sit down and you explain to the individual, as I said, that you are not his lawyer. If you don't explain that to the individual, and this is critical, if the individual walks away with the idea that you are his lawyer or her lawyer, if there is confusion on that point, that will always be construed against you. You can waive the corporation's privilege by not making clear that in this conversation with this employee, you represent the company, you don't represent the employee, and we'll talk about that. We'll talk about that in a little bit more in a minute. Okay. So, who's the client? We talked about that. There has to be an attorney-client relationship, and it's a little bit tricky with a corporation. It's less tricky with a person. Typically, the individual you're talking to is the client. If the individual that you're talking to is not the client, then you probably should not be talking about confidential information. So, and I'll just spend 2 seconds on that. If your client happens to be an individual, just be clear that you don't, for example, talk to the individual with anyone else in the conversation who is not a subordinate of you, who is not someone who is either employed by you for the litigation or for the transaction or for whatever it is that you're talking to the individual about. But I think individual representation is much less tricky than corporate representation. Okay, so that's who's the client. When is it in confidence? When is it not in confidence? When is the confidence waived or the privilege waived? If you don't maintain the confidence of the communication, if you inadvertently reveal the communication to a third party, then you have waived the privilege. You have waived the privilege. If you tell it to a third party, the privilege is broken. But not every disclosure will waive the privilege. There are 2 common common in situations where the privilege is not waived. And the first is the joint defense privilege, and that exists when you are in a typically in a litigation, when you're a defendant in a litigation, and there are other defendants in the litigation. You can reach an agreement with the other defendants in a litigation to share confidential information. That will not waive the privilege. The other typical way to maintain the privilege with others is what's known as the common interest privilege. These are not the same thing. Joint defense and common interest are not the same thing. The joint defense privilege attaches or can attach when you are jointly defendants. If you're not jointly defendants, there really is not a joint defense privilege. Or if you're not defendants, you have to at least assume or be in preparation for being a defendant. There has to be litigation threat. Common interest, though, solves the problem of, say, for example, you're working on a transaction with two corporations, and you want to keep communications between the two corporations. There can be a common interest privilege, but common interest is much trickier than joint defense. Joint defense is easy. You're all defendants. You've signed an agreement that says you're going to exchange information and that you will keep it confidential, and that the purpose of the exchange will be to further the defense of your client. Common interest is much trickier because it must be the case that you have a common interest. The information that you exchange, the privileged information that you exchange, must be in furtherance of a common interest. So if you think about that, when you are in a merger or an acquisition setting, and do the two corporations have a common interest? They probably don't, or at least they oftentimes don't. Their interests may, in fact, be adverse. Each one wants to get the best part of the bargain. So can you have a common interest privilege when you're working on two sides of a merger or two sides of an acquisition? You can, but it's trickier, and the law is very up in the air on common interest, as we'll see in just a minute. So, okay, what does it mean to have a common interest privilege? There has to be some privileged communication. We talked about the requirements under the that 1950 district court case laying out the requirements for attorney-client privilege. So there has to be a communication between the attorney and client that meets all of the elements of that case. Then the party that you want to share it with must have an interest in common with you. The sharing of the communication, of the privileged communication, must be to further that common interest. You have to be able to explain to someone if you are later in court and there is discussion about whether or not this information has to be disclosed because it's not privileged. You have to be able to explain how you had to share this privilege with the other side in order to further whatever the common interest is. And of course, the parties haven't waived the privilege. They haven't shared it with anyone outside the common interest agreement. Okay, so this is just a case, State Farm v. Harkins. It's a fairly recent case, 2010, that says the law on common interest is complicated. But there's a million cases that will say the law on common interest is complicated. And I put that in there just to raise awareness on your point that this is not easy, and you must think very carefully about common interest when you are entering an agreement, and then when you are sharing privileged information pursuant to a common interest agreement. And then this slide is just to make the point again that it's not obvious when courts will say common interest applies and when they will say it doesn't apply. So if you look, for example, at the Hewlett-Packard case, that was a case in which a patent was being sold. There was an opinion letter, as there typically is when you're selling a patent, that says this, in my opinion, is a valid patent. But that opinion letter is privileged, right? A patent lawyer wrote the opinion for the client. In the course of selling, the patent, the opinion letter is disclosed, but it's disclosed to the potential buyer under a common interest agreement. The court said, okay, that's fine. Common interest will attach in that case, even though you could argue that their interests were actually adverse because they're bargaining for how much they're going to pay for the patent. If you look at cases where common interest, the court found did not apply, look at the SCM Corporation versus Xerox case, which is a 1976 case from Connecticut. This also was negotiating an arm's length transaction. In the course of that transaction, some privileged information was shared with the other side. Very, very similar to the Hewlett-Packard, the Bausch and Lomb case. But that court said, look, I mean, the two sides had very different interests. Each side wanted to get the better bargain. How could there possibly be a common interest here? So if you are sharing information under a common interest privilege, you have to know what law is going to apply. Where are you? Where is the transaction? Is it going to be state law going to apply? Is federal law going to apply? If state law is going to apply, which state are you in? And take a look at the law before you willy-nilly agree that, yes, of course we have a common interest in this merger agreement or this acquisition agreement, and I will happily give you my files. The common interest might attach to that, might not attach to that. Inadvertent disclosure, the rules on that have become much, much clearer, relatively clear. The inadvertent disclosure rule, and this comes up, as I'm sure you all know, commonly in litigation where you have discovery requests for 10 zillion documents, and so you get the contract lawyers to review all the documents, and you turn over 9 zillion documents, and it turns out that 100 of them or 200 of them were actually privileged, so you try to get the privileged documents back. Well, it's not up here, but Rule 502 along with Rule 26b-5 are the two rules that you look to in deciding whether or not you can still preserve the privilege even though you've given documents over to the other side. And I'll tell you, it's not automatic, right? I mean, you would think that you'd be able to say, well, of course, it's inadvertent because we didn't intend to, we never would have intended to turn over to the other side our privileged information. That's not inadvertent. I mean, your bonehead mistake does not amount to inadvertence. Inadvertence has to be a disclosure that happened in spite of, or despite your taking every measure that you could reasonably be expected to take to prevent that from happening, right? So you have to be able to show things like, well, we didn't just turn this information over. We first had to come through here and look at it, and then we did a search for privileged documents, and then we did a privilege law, we did a very detailed privilege law. So the mere fact that you didn't mean to turn the documents over will not necessarily be enough. Although the law on this is a little bit, you have to sort of know what judge you're in front of. Some judges will allow it almost always to claw back the privileged information if you didn't really intend to turn the information over. Other judges, though, are going to ask, what did you do? Give me a long list of things that you did very carefully to try to prevent this. And if it slipped through the cracks despite all of the things that you've done, okay, then I will let you get it back. Okay, so we talked about the fact that it has to be, the communication has to be with the client. What is the client in the context of an individual? What's the client in the context of a corporation? Then we talked about the fact that it has to be confidential, and what does confidential mean in the context of common interests, and what does confidential mean in the context of joint defense. It also has to be for the purpose of securing legal services, communication with your client. That's for the purpose of securing legal services. And this just makes the point that I mentioned briefly before. This is a press release from Siemens where they are touting the fact that our general counsels are not just lawyers. They have a formative role and decision-making function in business operations. I mean, it's a wonderful press release, but I'm sure it will get used against them at some point when they're trying to make the point that everything the general counsel ever said or did is privileged. That probably won't hold water. I mean, you have to look very carefully at the context in which the advice was given. Was this really legal advice, or was this more commercial advice? All right. What about documents? And we've talked about documents just a little bit in the context of inadvertent privilege. It's one thing when you are saying something to your client. What about when you have produced documents that some of whom may have been authored by attorneys? Well, it is not enough that a document was authored by an attorney for the privilege to attach. I mean, that is certainly a good start, I suppose, if you have a document that you wrote, or typically it's going to be in-house counsel wrote. I mean, that's a nice starting point. But then you have to go a little bit deeper than that. The document itself has to reveal an attorney-client privilege. So you get these kind of disputes a lot in litigation where there's an email from the lawyer to the corporate client, and the email says something like, attached is a business plan that we think looks pretty good, and you might want to move forward. Does that make the business plan privileged? It probably doesn't. It might make the communication, it probably does make the communication privileged, assuming all the other requirements of attorney-client privilege were attached, that you should move forward on the business plan. Okay, fine, you can't turn over the covering email. But the document itself, I mean, unless there is something else in there that reveals legal advice, the business plan is probably not privileged. Okay, so that's the second case, Fish for the United States. It has to reveal an attorney-client privilege. Or it has to be something that was prepared at the direction of an attorney in preparation for a legal proceeding. So, and this is common with experts. I mean, if you consult with an expert and ask an expert to take a look at a bunch of facts and then give an opinion on it, and then he doesn't wind up being your retained expert at trial, is the consulting expert's information that he provided to you privileged? And chances are, if you have met all the other requirements that we talked about earlier, it will. I mean, there are ways to maintain privilege over information that was created by non-lawyers, as long as the information was created as part of a legal proceeding or in furtherance of obtaining legal advice at the direction of a lawyer. Okay, so that first half of my chat, very quickly, basic discussion of what the attorney-client privilege is in the United States. And I suspect that most of you knew all of that anyway, and that it was a refresher for you, and I'm glad to be able to provide you a brief refresher. But I do that so that you can contrast the law of attorney-client privilege in the United States with the law of attorney-client privilege outside the United States. for those of you who haven't dealt with foreign transactions a lot, you should understand lawyers outside the United States are not always the same animal as lawyers inside the United States. If you're dealing with a common law country, if you're dealing with UK, Canada, Australia, a common law country, then everything you know about what it means to be a lawyer will in large part translate. But if you're dealing with a civil law country, France or Belgium, or if you're dealing with an Asian country like Japan, China, who is a lawyer and what role a lawyer serves is going to be very different. In many places, for example, think about Japan, it was not the case until fairly recently that lawyers in Japan even went to law school or were required to go to law school. In many foreign jurisdictions, there is not a formalized bar. There's not the equivalent of the Virginia State Bar or not the equivalent of the American Bar Association. So there's not a formalized rule of ethics that a state bar has put forward. And all of that becomes important because part of the reason that courts are willing to attach attorney-client privilege to our conversations with our clients is because there are these procedures in place, the state bar rules, the ADA rules, that require that we do things in a certain ethical, professional way. When you step outside the United States, that may or may not exist, and so that sometimes will color whether courts are willing to give the communication between that foreign lawyer and a client the same level of protection that they're willing to give between a U.S. lawyer and a client. One thing that you have to be very aware of, if you're not currently, is that in-house lawyers in many, many, many jurisdictions, there is no privilege between what an in-house lawyer says to anybody else in the corporation. The idea being that there is not sufficient independence. If you are an employee of the corporation, you're not sufficiently independent of the corporation that your advice should be given in the same way as, or the same protection at least, as an independent lawyer. The other thing that you have to keep in mind, in the United States, the rule everywhere is that the privilege belongs to the client, right? The privilege belongs to the client. It doesn't belong to us. It belongs to the client. That's why it is such a violation if we inadvertently break the privilege, waive the privilege, release confidential information. If we do it with the client's consent, then it's not a problem at all. In many foreign jurisdictions, the privilege is not held by the client. The privilege is held by the lawyer. The lawyer gets to decide whether and when to reveal information. Okay, so as I said, if you're dealing with a common law country, the law of privilege is going to look pretty similar to the law of privilege in the United States and Canada. They do, for example, if you're an in-house lawyer, accord them the same level of, or accord those conversations the same level of protections that an out-house lawyer would have. Although in Canada, as in the United States, it's only those conversations in which the in-house lawyer was acting as a lawyer, not acting as a business person. In Europe, Europe is very difficult, very difficult. You have to be very, very aware of what jurisdiction you're in and what jurisdiction's rules may ultimately apply to the matter you're involved in. So, for much of Europe, there's the European Union, not for all of Europe, but for much of Europe, there's the European Union, and the European Union has a set of laws and a set of rules with respect to attorney-client privilege, and then the member states have their own separate set of rules with respect to attorney-client privilege. Almost everywhere in Europe, there is some form of privilege that is recognized. And, but I say privilege, I mean, it's different in, say, for example, France. It's very different in France than it is in the UK. In the UK, you're in a common law country. The privilege is very similar to what it is in the United States. In France, you're it is not a common law country. You're dealing with something called professional privilege, which we'll talk about in just a minute. Okay, I think that's it. So if you are dealing in a matter that is governed by EU law, again, there's not a statute that deals with, or even a regulation that deals with attorney-client privilege at the EU level. There is a case called AM&S Europe versus the Commission, which is really the seminal case on attorney-client privilege in the European Union. In this case, the privilege was found to attach to communications related to the investigation by the EU and communications involving independent lawyers. This case laid the foundation for the rule in the European Union that if you are an in-house lawyer, the privilege is typically not going to attach. This was about notes that were taken by, fortunately in this case, not in-house lawyers, by independent lawyers. So the fact that they were taken by independent lawyers allowed the EU to find that the privilege attached. All right, we've talked about most of the stuff, so I'm just going to go through this quickly unless there's any question about it. Whoops, I went backwards. Okay. In the United Kingdom, the rule is very similar to the rule in the United States. It is not exactly the same, but it's pretty close to the same as in the United States. They talk about two different privileges, the legal advice privilege and the litigation privilege. We sort of combine both those concepts under the rubric of attorney-client privilege. But in the UK, if communications for the purpose of seeking or giving legal advice, then it's going to be typically privileged if it was in confidence and if it was between a lawyer and a client. Or if the communication was in respect of a litigation that is either ongoing or that is likely to happen, then that also will likely be privileged. And that's the same, generally the same rule as in the United States. In the United Kingdom, they do recognize the privilege for in-house lawyers. Okay, and then the last point on this slide, which is a pretty important point. In the UK, they will recognize a privilege between a lawyer and a client, even if the lawyer is not barred in the UK, even if the lawyer is not qualified in the UK. If you're in the EU, if you're dealing with a matter that's governed by EU law, that's not true. They will only recognize the privilege between a client and an attorney that is barred in one of the EU member states. Legal advice privilege is pretty similar, as I said, to the privilege in the United States. I'm just going to go quickly over this unless there's questions about it. And again, litigation privilege applies when adversarial proceedings are reasonably in prospect. That's the British formulation, reasonably in prospect. Okay, so if you're on the continent, though, if you're not in a common law country, you're typically not going to even have something called attorney-client privilege. They have what is broadly referred to as professional secrecy. So it's not a privilege that is limited to lawyers. Any of the recognized professions, lawyers, doctors, accountants, and a few others, there is an obligation on the part of the professional not to disclose information that was given in confidence to that profession. But the obligation and the information, the privilege, to say to call it a privilege, rests with, in this case, the lawyer. So if you are on a matter, if you're working on a matter with a French company, and the French company is represented by House Counsel France, the communications between counsel and the company can be privileged, but the privilege is held by the lawyers and not by the company. So if the company wants to reveal privilege, wants to, for example, if you're in a criminal investigation and the company has done an internal investigation entirely privileged and wants to reveal some of that to the United States Department of Justice, that's up to the company in the United States. It's not in France. If you're dealing with a French company, that decision rests solely with the lawyer. Confidentiality is pretty similar on the continent as it is in common law countries, and that is that communication has to be made and maintained in confidence. Okay, so the most recent privilege case law in at least the EU is AkzoNobel versus the European Commission. This was a cartel matter. There was the Dawn raid where members of the EU went to AkzoNobel in the UK, in London, or outside London, in Manchester, I think, and seized emails that were clearly would have been privileged under UK law, clearly would have been privileged under US law. It was between the managing director and the in-house counsel. In-house counsel was employed as an attorney, not as a business person. The advice was given in his capacity as an attorney, not as a business person. The in-house counsel was a member of the organized bar. He was a member of the Dutch bar, the Netherlands bar. The employment contract that the in-house counsel had, and that's typically how employees work in Europe, is how an employment contract. The employment contract stated explicitly that the lawyer was independent of the company, and that is the advice that he gave to the company. The independence of this advice prevails over any other loyalty that he might feel to the company. So Akzo said all of these mean that those emails that you seized in Manchester are privileged. The European Commission said, no, that's not true, they're not privileged. It was an in-house counsel who made the emails under our rules. In-house communications are not privileged. So Akzo appealed to the first level court in Europe, which is called the Court of First Instance. Let's see. So I'm sorry. This is in the Court of Justice, the European Court of Justice, which is the court. The government of the United Kingdom, the government of the Netherlands, the Irish government, the IBA, and the ACC all filed briefs saying, because of the independence of this lawyer, you should treat the communications as privileged. Ultimately, the court said no. He's an in-house lawyer, so the communications are not privileged. That's our rule. That rule is not going to change. I mean, the folks that followed this thought this would be the time that Europe would say, well, shoot, the reason you have that rule is because you think in-house lawyers are not sufficiently independent to give independent advice to corporations. Here we have a case where clearly this lawyer was independent. He was a member of the bar. His contract said he was independent. The EU said no, it doesn't. I mean, the European Court of Justice said no, it doesn't matter. He was a in-house lawyer, and our rule was that no communications with in-house lawyers are privileged, so this communication is not privileged. So, when you are dealing in a matter that involves multiple jurisdictions, you have to think about which jurisdictions are involved. Which jurisdictions may be involved, because in the Akzo case, the advice was given by a Dutch lawyer to Akzo in the UK, right? In the UK, dealing with the UK, you want to think, well, shoot, it's the UK laws are going to apply. This will be privileged. The EU laws applied because the investigation was not by a UK agency, but was by the European Commission. So even if you're in a jurisdiction whose laws are similar to the United States on privilege, you have to still think, well, is there another jurisdiction whose laws might apply to this? And if you're in Europe, it's really common that the EU law may apply, even if you're in a member state that has privilege laws similar to the laws in the US. So what happens if you're in a US court and there's lots of privilege laws that could apply because you're in a multi-jurisdictional matter? Well, a US court is just going to apply the choice of law rules that I'm sure all of you know well. If it's multiple states and it's a state with the most significant relationship, their privilege laws will apply. If it's a US state or a federal jurisdiction and a foreign jurisdiction, then the most common test is what's called the touch-base test. It's a communication touch-base with the United States. If it was an email to someone in the United States, or if it was an email from someone in the United States, then a U.S. court is likely to say, assuming all the other requirements of privilege were there, that that privilege attached and that communication is privileged. That's not to say what a European court would say. A European court might come to a completely different conclusion. So you also have to know what forum you're in, but at least in the United States, that is typically how they would try to figure it out. Okay, so what do you do about this? Well, when you are in a matter that has multiple jurisdictions, one thing certainly you should try to do if you can is make it as US focused as you possibly can. Sometimes you have no control over that, but to the extent you do have control over that, to the extent you can put in the contract, if it's a contract, that US law applies, to the extent that you can put arbitration forms or dispute resolution clauses in the contract that favor the US. Do that. To the extent that you can rely on US attorneys, do that. To the extent that you can rely on attorneys who are not in-house counsel but outside counsel, if you're dealing with matters outside of the United States, do that. So try to have as many, we talked very briefly about the touch-base test. Try to touch base with the US as much as you possibly can. If you can't, if you're in a matter that is mostly or even partially foreign, if you're at the beginning of the matter, hire outside counsel. Try not to rely on inside counsel. This becomes tricky, very tricky, because in-house counsel lawyers, just like you and I in Europe, it becomes hard to say, well, we can't really use any of your advice because it's not clear that it will be privileged. But they also understand this point, and it's usually a good thing when you're in Europe to try to hire outside counsel. If you're at the beginning of a multinational project, a merger or acquisition or other contract or other business dealing, give thought to what in-house counsel can do. I mean, if you're particularly if your client is a foreign corporation, but even if it's a U.S. corporation and the foreigners are on the other side, what reasonably can in-house counsel be asked to do that would not somehow invalidate the attorney-client privilege? So, this presentation zoomed through a whole lot of law very quickly, and the point of it was not necessarily to make you all experts in the law of attorney-client privilege in the U.S. and foreign jurisdictions. The main point of it was to sensitize you to the fact that the laws are different, that there are some pretty good sources that you can turn to in the U.S. To figure out what is covered by attorney-client privilege. There are less good sources to turn to when you are outside the United States. But if you're in a matter that touches a foreign jurisdiction at all, it is something that you have to think carefully about, that you have to spend some time on and give thought to. So any questions about any of this before I sit down and leave you all? No? Well, at least for myself. All right, yes, sir.
Could you just address briefly, what does it look like, say, in a litigation context when privilege is actually tested? What is it important to analyze that?
So, I mean, that is typically going to come up in discovery, right? When you have you turn over documents to the other side, or gotten documents from the other side, and the documents have included purportedly privileged information, and someone is making the claim that the purportedly privileged information should be returned. So, first thing, I mean, you try to work it out with the other side, and usually you can. I mean, especially in very big litigations that have a lot of documents, because the other side knows it's very likely that they let slip some privileged information as well. But if it's a smoking hot document that the other side really wants to use, they may not be that willing to say, this is privileged. So if they're unwilling to give it back to you, if they're unwilling to agree, then you've got to file a motion with the judge, if you're with the judge, or with the magistrate, if you're not yet with the judge. And it will typically be filed under the protective order. You'll have a protective order that has been entered that governs discovery generally, and you will file a motion to enforce the protective order with respect to these documents that are privileged, or you can file a motion to quash the subpoena with respect to these documents. And then you've got to lay out for the judge as persuasively as you can why the fact that these documents slip through your net should not be held against you, or if it is held against you, why the judge should still give them back to you. And that's what goes back to what I said earlier. You have to have, in your litigation, you have to have put in a system in place that is reasonably designed to catch privileged documents. You have to, if it's a big litigation and you're using contract lawyers, you have to have done a privilege review. You have to have put together a privilege log. You have to have shown that you didn't just rely on the contract attorneys to pull out the privileged documents, but that there was a review at a higher level. The more that you can show that you took very reasonable steps to make sure that privileged information doesn't go to the other side, the more likely you are to prevail under Rule 502 that it was an inadvertent disclosure. But as I also said during the presentation, a lot of it will depend on the judge. You have to know your judge, and if your judge is a real stickler on this kind of thing, then you just have to try much harder at the front end not to let any slip through. Yes, sir?
Kind of piggybacking off of that, I know that a lot of these reviews are now being conducted by computers, at least at the first level. How receptive are you finding the courts when something does slip through, or a judge is looking at to what extent that is a sufficient system in place, even if you do have FERC laws and everything else like that?
If that's all you did, if the answer is, well, we rely on coal, and coal is really expensive, we spend a lot of money on this predictive coding, and it just didn't work. I'm sorry. That will not work. You have to have done much more than that. Now, can you rely on predictive coding at all? Of course you can. But that there must have been a check beyond that. You must have had an associate, overseeing this and discussing it with a partner on the matter. And the more that you can show, you put in place reasonable methods to try to catch this better. I mean, I know that's not a terribly straight answer for you, but the more you can do, the better. And that's that. It's tricky because clients don't want to pay for that, and clients will say, come on, you pay a lot of money for coal, and it's predictive coding, and it's all going to be fine. It's tricky, and you have to explain to them what the downside is if something does slip through, and what this can mean to the litigation, what it can mean to you personally. If at the end of the day, they disagree with you, that would be hard. I haven't run into that situation. Typically, if you can explain to the client in a reasonable fashion why what you want to do is really what needs to be done,